Hello and welcome to the webinar. My name is Emma Houston and I'm here today with my colleague Elisa Hewen. We are practice leaders at LegalVision. Today we will be breaking down what you as a tenant need to do before signing your lease. At LegalVision, we believe that a lease is more than a contract. It is the start or the growth of your business.
It's important to get the lease right because it is a long-term contract with serious implications, and if done right, it can provide your business with either years of stability or flexibility to upgrade premises as your business requires. The beauty of all this is that you're in control of the process.
This webinar looks at three key areas: pre-lease negotiations, signing a heads of agreement or lease proposal, and reviewing the draft lease.
Turning to negotiations, it's important to work out what you need before you agree to anything with a landlord or agent. So to ensure you get the best deal, research things such as the usual rent for your area and the likely type of rent increases. Know what you need out of the premises. For example, if you run a franchise business, you want your lease term to match the term in your franchise agreement. Or if you're just starting out and if you know your business will grow within the next 5 years, you might want a short-term lease to allow you to upgrade your premises with your business as time progresses.
When negotiations of the commercial lease are complete, they should be written down and signed off by both the tenant and landlord. This process is commonly known as either preparing a heads of agreement or a lease proposal. The landlord then uses this document to prepare a draft lease for review by the tenant's lawyer. The following items should be included in a heads of agreement as a minimum: the premises, including any associated storage spaces and car parks, the start and end dates of the lease, any further terms granted under the lease, the rent, both the starting rent and the rent review mechanism during the lease term and further terms, details of any outgoings payable on top of rent, any work the landlord must complete, being a promise to complete items in the property such as a new bathroom or repainting before the tenant moves in, whether any legal costs are to be passed on to the tenant and what they are, details of the bank guarantee or security bond, as well as details of any insurance required under the lease. If there is anything particular for the premises, such as a lease incentive, a rent-free period, or a proposal to sublet part of the premises, this should be contemplated in the heads of agreement also. Finally, the heads of agreement should deal with make good of the premises. And remember, before signing any heads of agreement, it is important that you check whether the document is binding or non-binding. You should also make sure all agreed information is included, because if you try to enforce something that slipped through the cracks in the heads of agreement afterwards, you may face a difficult battle. In general terms, a heads of agreement is usually an informal document with neither party being bound until all parties have signed the formal lease documents. However, you should approach this statement with caution because some heads of agreement contain terms which specifically provide for them to be binding. And in those cases, you can face a claim for damages or lose money if, as a tenant, you do not end up proceeding with the lease.
The next step is the pre-lease process, is the landlord's lawyer submitting the draft lease. Leases can be a complex piece. Some are more than 60 pages long, and they represent a long-term financial commitment. So it's important you obtain detailed advice. What follows are some key things to look out for before signing on the dotted line. We'll start off with retail leases. retail leases are different to commercial leases. Each state or territory in Australia has its own unique retail lease legislation, which offer protection to tenants on issues such as disclosure, costs, and other issues that regularly face tenants. It's important to check whether the retail lease legislation in your state applies to your lease, because it could mean you do not have to pay lease preparation costs or key money, and you should be aware of these rights before you sign the lease. In terms of costs, so what do you need to pay when entering into a lease? Be prepared to pay lease review or preparation costs, a deposit, the first month's rent on the property, and provide a security deposit plus pay for the fit out and setup of the premises. So for retail leases, legislation will usually limit the cost that the landlord can seek from the tenant, including for lease preparation and some repair costs. However, the extent of these limitations differ from state to state. For example, while the Victorian legislation explicitly prohibits landlords from charging lease preparation and negotiation costs, the New South Wales legislation is not as clear and does not include negotiation, meaning many landlords in New South Wales will attempt to get around this by charging tenants for lease negotiation costs rather than lease preparation costs. So the difference is really all in the wording. Next, we turn to security deposit. A security deposit is generally in the form of a bank guarantee or cash bond, and as a rule of thumb, it's the equivalent of around 3 months' rent and outgoings. However, this varies from lease to lease, and in some cases, it can be as much as 6 months' rent to put up front as security. You should also be aware of hidden fees, such as survey fees, hoarding fees, or design review fees for the premises. These can add up, and if the premises are retail premises, the landlord has an obligation to disclose these likely costs to you before signing the lease. Finally, a tenant can also expect to pay registration fees and in some cases consent fees for the landlord's mortgagee.
So now we turn to rent. Rent is a really important aspect of any lease, and you need to make sure before signing up to a lease that the starting rent and the ways in which the rent will increase during the term and any further terms are crystal clear to you. Rent is usually reviewed during a lease term on the anniversary of the lease commencement date. So basically once a year, and we'll mostly use one of 3 methods: Consumer Price Index, or CPI as we'll call it for the rest of this webinar, a fixed percentage review, or a market review. A CPI review is a review of the rent which aligns with movements in the Consumer Price Index published by the Australian Bureau of Statistics. A CPI review is considered to be the fairest commercial rent review method for tenants, as it keeps pace with the economy, and at the time of recording this webinar, it is relatively low, but that is not always the case if inflation is high. A fixed percentage review is very common and is beneficial to all parties in the sense that it allows all parties to the lease to know what the rent increase will be throughout the initial term. Many of our tenant clients appreciate the certainty that comes with this, as it allows them to forecast business budgets for the coming years, knowing what the rental outlay will be. Generally speaking, at the time of recording this webinar, a fixed percentage of 5% or lower, depending on where the premises are situated, is considered a fair and favourable percentage. Often, landlords may choose to use a combination of fixed percentage and CPI for a rent review. For example, the rent review method would be CPI plus 2%, or the greater of CPI or 4%. This will be a matter of negotiation for the parties during the initial lease negotiation process before the heads of agreement are prepared. And turning to a market review, these will more typically take place on the exercise of an option, or in the case of a very long-term lease, every 5 years or so. And It means that the rent will be reviewed to determine the current market rent of the premises as of that date. Most leases contain provisions to break a market review dispute if the landlord and tenant cannot agree on a new rent, and allow for independent valuation if a result, if an agreement cannot be reached. A ratchet clause should also be considered where market review is concerned. A ratchet clause is a clause that stops the market review decreasing the rent, noting it must stay the same or be greater than the current market rent at the time of the review. Ratchet clauses are not permitted in retail leasing legislation, but do make regular appearances in commercial leases. It is important to look out for them when negotiating and reviewing a new lease.
So turning now to the issue of security, the majority of leases will contain a raft of clauses requiring a tenant to supply the landlord with security in case they default on the lease or abandon the premises and do not make good. Security usually takes the form of a security deposit or a bank guarantee. A security deposit just means a cash bond. A bank guarantee is an undertaking from the bank to guarantee the payment of the amount noted on the bank guarantee to the landlord. The lease then gives the landlord the right to cash the bank guarantee in circumstances where the tenant breaches the lease or fails to pay rent. You should note that a bank guarantee can take 3 to 4 weeks to obtain from a bank, and perhaps factor that in to your lease negotiation process. Personal guarantees, on the other hand, may also be required as a form of security if the tenant is a limited liability company, and usually this is noted with the letters Pty Limited at the end. A personal guarantee is a promise that all of the guarantors, who are usually the directors of the tenant company, will be responsible for the debts of the company should it default on rent. Note that most personal guarantees are continuing and irrevocable and are joint and several. As a result, prospective guarantors should be wary of providing such a guarantee as it places personal assets at risk, such as your property and motor vehicles. Alternatives to a personal guarantee that both parties can consider may include increasing the security deposit or the bank guarantee to the equivalent of 4 to 6 months rent, or limiting the personal guarantee with a monetary cap such as $20,000.
It is also common to find relocation and demolition clauses in leases. These provisions set out the rights and obligations of both parties if the building or property the premises is located in is to be refurbished or demolished entirely. These are important to review because it could see your lease end early, or it could see you at great expense and inconvenience having to relocate your premises within a shopping centre. Rights in cases of relocation and demolition will vary depending on whether or not there are specific clauses allowing for this in the lease, and also whether the retail leasing legislation applies to the lease. For example, retail legislation in New South Wales provides that a landlord may only relocate a tenant if the landlord has provided the tenant with 3 months' notice and offered a lease for the remaining term on substantially the same lease terms. The tenant is also to be provided with a right to terminate the lease within 1 month of receiving a relocation notice, and limited compensation may be payable by the landlord, such as the reasonable costs of relocating the tenant to new premises within a specific centre. Demolition clauses are similarly regulated under retail legislation. For commercial leases, the terms of any relocation or demolition clause is up for negotiation between the parties prior to the lease being finalised. And if included in a lease, a relocation or demolition clause should provide for and take into account the timing of the notice to be provided to the tenant for a prospective relocation or demolition, and any likely compensation. If in doubt, always get it checked out before signing anything without knowing your rights.
We now turn to the landlord's incentives. A landlord may offer some form of incentive to entice a potential tenant to enter into a lease, such as a rent-free period or fit-out contribution. It doesn't hurt to ask for one of these. The most common examples of incentives are, and it really comes down to what type of business you're running as well. So the first type is a rent-free period, and what this means, it's basically an offer of essentially a number of weeks or months where the tenant does not have to pay rent. This can be taken in one go, such as the first 3 months starting from the commencement date, or can be spread over the lease, such as 1 month each year for 3 years. This can be a way for the landlord to induce the tenant to enter into the premises. You can also ask to be given an incentive in the form of a rent reduction or abatement, where the incentive is spread over the lease term. For example, the landlord may offer 3 months rent-free to be spread equally over 12 months, which means the tenant would pay 75% of their rent each month of the first year. With fit-out contributions, this usually takes the form of a cash sum paid by the landlord to apply to the tenant's fit-out works. So the landlord can either pay this contribution to the tenant as a reimbursement once the tenant provides the landlord with receipts or invoices of the works, or the landlord can carry out the fit-out works for the tenant to the value of the the incentive amount. Note that a landlord will generally not release a lease contribution payment until the lease has been executed, security provided, insurances in place, fit-out plans and receipts has been submitted.
And when negotiations are complete and the terms of the lease agreed upon, taking into account any amendments negotiated between the parties, the lease must be finalised and signed. In terms of signing the lease, note that each state has different requirements. For example, New South Wales has strict signing requirements which must be adhered to for leases that are to be registered. Retail leasing legislation may also impose further obligations. Using New South Wales as an example again, the landlord must sign and return lease documents to the tenant within 3 months for a retail lease, whereas registration is not compulsory in Victoria and the requirements are much more relaxed. That concludes our webinar. Thank you for listening. If you have any questions about the webinar today or leasing in general, please call us on 1300 544 755 or visit our website www.legalvision.com.au.